Chairman. Congratulations to each of you and to your families. We're delighted that y'all are here with us today. Mr. Papillon, I want to come to you and go back to this case with Pastor Spell. That is a thing that concerns me because at the time, Governor Edwards thanked the protesters. So it was okay for protesters to assemble in Louisiana, but not okay for people of faith to assemble. So that is, in my opinion, and I would think to you, that that would have been the unconstitutional part of this approach of going against Pastor Spell and ruling against Pastor Spell. So what I'd like to hear from you is why you would see this as not being that restriction on free speech. Why did you think that was acceptable, and what was the legal basis that you went to for that decision?
Thank you, Senator. I'm not familiar with the part about the protesters, but I'm very familiar with the Spell case.
It's a quote that I have in front of me. He thanked the protesters at the time and stated that they were appropriately expressing their concerns and exercising their First Amendment rights.
All right. Again, it's just something my role was in the Spell prosecution, but let me explain that, if I may. It is that in the very early stages of the pandemic, states were faced with the very difficult collision of the very important right to religious expression and the state's power to protect the public. And the law clearly protects religious liberty, but it also gave the state the power that it did. And we later got guidance from the United States Supreme Court in some very important cases. And I believe that had those cases been decided earlier, the order that the governor wrote, which I didn't write, would likely have been written differently. And I didn't choose to prosecute the pastor, but as a lawyer, I represented my client, the state of Louisiana. If I were to be confirmed as a United States district judge, I would very scrupulously follow the First Amendment and the tests that our Supreme Court and the U.S. Fifth Circuit have made very clear, that when a secular institution is treated more favorably than religion, strict scrutiny applies, and the state needs to show that whatever remedy it wants to apply is narrowly tailored to achieve the result. And we can't assume the worst, as the courts have said, when people go to church, and the best when they go someplace else like work or the mall. And that is today, I think, a very clear principle of law that I would follow as a judge.
Okay. Well, I will tell you that's the thing that really concerns me, is the way that I appreciate your explanation, but the free exercise of religion is very important to Tennesseans. It's important to the religious organizations that call Nashville, Tennessee home. And I'm sure you're aware that there are many. And to have a case where it seems there is a subjective opinion that allows one type place of gathering, allows another type place of gathering, but disadvantages and disallows the exercise of religion, that causes tremendous concern. It seems like an inconsistency of the approach. And as I've reviewed your record, have been concerned about that. My time has just about expired. Mr. Herson, I'm going to come to you and Mr. Daniels with a written question pertaining to your judicial philosophy in your approach on some issues. I was concerned, Mr. Herson, of the remarks you made to Senator Graham on fentanyl and the awareness of fentanyl and the impact that has on our community. Thank you, Mr. Chairman.